This is the ruling in respect of the first interested parties notice of motion application dated 9th June 2025. The first interested parties notice of motion application dated 9th June 2025 seeks the following orders. 1. That the first interested parties notice of motion application dated 9th June 2025 be certified as urgent. 2. Milimani High Court Constitutional and Human Rights Petition number E083 of 2025, Honorable Lady Justice Martha Koome versus Judicial Service Commission and four others, be forwarded to the Honorable Chief Justice to delegate to the Deputy Chief Justice the function of assigning an uneven number of judges of the High Court, excluding Honorable Mr. Justice Charles Kariuki, Honorable Mr. Justice Lawrence N. Mugambi, and Honorable Mr. Justice Bahati Mwamuye, to hear and determine that petition. 3. That the remaining 6 consolidated petitions, being Milimani HCCHR PET number E079 of 2025, petition E086 of 2025, petition E087 of 2025, petition E089 of 2025, petition E090 of 2025, and petition E098 of 2025 be forwarded to the Honorable Chief Justice to assign an uneven number of judges of the High Court, excluding Honorable Mr. Justice Charles Kariuki, Honorable Mr. Justice Lawrence N. Mugambi, and Honorable Mr. Justice Bahati Mwamuye, to hear and determine those 6 consolidated petitions. 4. That the Honorable Chief Justice and the Honorable Deputy Chief Justice should comply with the precedent and principles set out in case law with respect to the selection of justices and the empanelment of an uneven number of judges, to hear and determine the petitions herein. 5. That the bench herein, comprising of the Honorable Mr. Justice Charles Kariuki, Honorable Mr. Justice Lawrence N. Mugambi, and Honorable Mr. Justice Bahati Mwamuye, consequently recuse themselves from any further hearing and determination of the 7 consolidated petitions herein. And 6. That the cost of the application be provided for. The first interested party's notice of motion application is supported by the affidavit of Nelson Harvey, dated 9th June 2025, which elucidated the grounds advanced in support of the application and which are summarized as below. That the Honorable Chief Justice, as the petitioner in Milimani High Court Constitution and Human Rights Petition number E083 of 2025, had a clear and undeniable conflict of interest when she exercised her constitutional discretion in selecting and thereafter appointing the 3 members of this bench to hear and determine a petition in which her ladyship is the petitioner, and consequently, that discretion ought not to have been exercised by the Honorable Chief Justice, but rather by the Honorable Deputy Chief Justice. 2. That the Honorable Mr. Justice Lawrence N. Mugambi and the Honorable Mr. Justice Bahati Mwamuye are both clearly and undeniably beholden to the Honorable Lady Justice Martha Koome, as she was the chairperson of the Judicial Service Commission that recommended each of those 2 judges of the High Court for appointment as judges of the High Court of Kenya. 3. That the 3 members of the current bench are relatively junior and inexperienced when compared to the members of past benches of the High Court who heard and determined petitions regarding the broader thematic area. 4. That noting the gravity and significance of the matters at issue in the subject consolidated petitions, a bench or benches comprising of 5 or 7 judges of the High Court with similar lengths of judicial experience as the petitioners and with varied judicial philosophies, ethnic backgrounds, and gender representation ought to have been appointed by the Honorable Chief Justice and the Honorable Deputy Chief Justice, respectively. And finally, that overall, the selection and empanelment of the present bench was unconstitutional and illegal. The relative position of the other party with respect to the first interested party's notice of motion application dated 9th June 2025 is as follows. First, 14th and 15th interested parties argued that the Honorable Chief Justice's action of empaneling this bench undermines the constitutional guarantees of fair administration and fair trial, as well as the core values of integrity, transparency, and accountability. Counsel submitted that by acting as a judge in her own cause, in quotes, at the administrative stage, the Honorable Chief Justice fell short of the standards of leadership and integrity required of her office under Article 73 of the Constitution, which demands objectivity and impartiality in decision-making and eschews any improper motives or conflict of interest. It was contended inter alia that Article 73, Clause 2, Paragraph B of the Constitution imposes upon the Honorable Chief Justice a constitutional obligation to eschew any personal interest that conflicts or may appear to conflict with the discharge of public duties, and to make an honest declaration of any such interest. The first interested party applicant particularly emphasized the Judicial Service Code of Conduct and Ethics Regulations 2020, which are binding upon all judges, codify and reinforce these constitutional imperatives. It was argued that Clause 20 of the said code, which enjoins a judge to, and I quote, use the best efforts to avoid being in situations where personal interest conflicts or appears to conflict with the judge's official duties, close of quotes, and Clause 21, which provides that a judge, and I quote, may recuse himself or herself in any proceedings in which his or her impartiality might be reasonably be questioned, I close quotes, including where a judge is a party to the proceedings. By the standards set forth under the foregoing constitutional and statutory provisions, the applicant contends that Honorable Lady Justice Martha Koome, being the petitioner in the subject petition, was under a duty to recuse herself from the process of constituting the bench to hear and determine the said petition. It is argued that she ought to have delegated that function to the Deputy Chief Justice, or alternatively, to have permitted the empaneling of the bench through an impartial and transparent mechanism. The applicant's position is that the failure by the Honorable Chief Justice to so recuse herself and to ensure an impartial bench assignment process rendered the proceedings incurably defective from inception, thereby vitiating the legitimacy of this bench and engendering a reasonable apprehension of bias in favor of the petitioners. The first interested party applicant noted that each of the three honorable judges on this bench had previously handled interlocutory applications in some of the consolidated matters before their consolidation, with two of the judges proceeding to issue conservatory orders favorable to the petitioners. The applicant submits that by granting such orders, the judges had, and I quote, had each already pronounced themselves, close quotes, to some extent on issues in dispute, and thus a fair-minded observer might question their impartiality in the final determination. Secondly, the applicant argues that Honorable Mr. Justice Lawrence Mugambi and Honorable Mr. Justice Bahati Mwamuye are relatively junior judges appointed to the High Court during Chief Justice Koome's tenure as chair of the Judicial Service Commission, with Mugambi judge having been sworn into office in December 2022, while Mwamuye judge was sworn into office in May 2024. Mr. Nelson Harvey argued that these two judges, and I quote, are perceived to be beholden to the Honorable Chief Justice, close quotes, due to the fact that they were interviewed, recommended, and appointed as judges during her ongoing tenure as the Chief Justice. Although no personal misconduct is imputed to the judges, the applicant argues that the objective perception of their perceived loyalty or perceived indebtedness to the Honorable Chief Justice cannot be ignored, given human nature and career dynamics. Thirdly, the applicant contends that the Honorable Chief Justice, in selecting this particular trio of judges, allegedly failed to take into account the essential considerations of expertise, experience, and diversity, contrary to established practice and precedent. It is argued that the three judges are relatively new to the bench, and none is especially known for expertise in complex constitutional adjudication or the subject matter at hand. It is further argued that the empanelment does not reflect regional, professional, or gender diversity, and it included no, and I quote, senior judges or peers, close quotes, of the petitioners, contrary to the historical trend in matters involving senior judges. In the applicant's view, a bench of three relatively junior judges who owe their recent appointments to the Chief Justice gives an appearance of a hand-picked team that may tilt in favor of the petitioner judges. The parties in support of the application placed substantial weight on the recent Court of Appeal decision in His Excellency Rigathi Gachagua and 5 others versus Thomas Kimotho Maingi and 80 others, 2025 EKLR, which dealt with a Chief Justice's role in bench assignment. In that case, the Court of Appeal outlined some of the factors that a Chief Justice should possibly consider when empaneling a bench under Article 165, Clause 4. The appellate court stated those factors include, and I quote, selecting judges with varied legal philosophies, regional representation or professional backgrounds, prior involvement in related matters, the sensitivity of the case and the corresponding need to uphold public confidence in the judiciary, avoidance of conflicts of interest to ensure impartiality, and of course, the workload and ability of the proposed judges. Close quotes. The applicant argues that the Honourable Chief Justice's empanelment of the current bench deviated from these principles, particularly the avoidance of conflict of interests and ensuring public confidence. The party supporting the application further observed that the Court of Appeal, in what has come to be referred to as the Gachagua case, pertinently posed a rhetorical question in the following terms. So what is to happen when the Chief Justice is, for whatever reason, absent, or when a matter certified as requiring empanelment relates to a matter where the Chief Justice is a party or substantially relates to the office or person of the Chief Justice? It was submitted by the Court of Appeal. It was submitted that the Court of Appeal proceeded to answer that question by reference to comparative Commonwealth practice and judicial precedent. In particular, reliance was placed on the decision in Leina Conchella and others versus Chief Justice of Kenya and others, 2021, KEHC 12609 KLR, wherein Chief Justice David Maraga, upon being named as a respondent in those proceedings, duly and appropriately delegated the function of empaneling the bench to the then and current Deputy Chief Justice, Honourable Lady Justice Philomena Mwilu. The applicant drew the court's gaze to the decision of the UK Privy Council in Yakub and another versus the Queen, 2014, UKPC 2022. In that case, the presiding judge appointed a judge to an appellate panel that was to hear an appeal from the presiding judge's own first instant decision. The UK Privy Council held that the impugned action carried an unacceptable appearance of bias, observing that, and I quote, appointing a judge to hear an appeal from himself carries an appearance of lack of independence and impartiality, which would impact on an objective, informed observer. Close of quotes. By analogy, the applicant argues that the Honourable Chief Justice's action of constituting a bench to hear and determine a case in which she is the petitioner is indefensible in light of the persuasive precedent of the UK Privy Council decision in Yakub. The applicant concluded by pointing out that the UK Privy Council quashed the impugned proceedings and directed that a new panel be constituted by the next most senior judge who was not involved in the matter, and the applicant sought that the same applies in the present scenario.
The application is formally opposed by the petitioner. The respondent.
The applicant has not met the strict threshold for recusal or disbandment of a bench, and that the application is driven by extraneous motives, possibly to delay the hearing of the petition or to engineer a more favorable bench. A preliminary objection raised by the sixth respondent is that the application is barred by doctrine of res judicata, and the counsel for the sixth petitioner points that this very issue on whether the first petitioner could lawfully empanel the bench to hear her case was raised, argued and conclusively determined by the High Court in ruling delivered on 25th April 2025 by Honorable Mr. Justice Lawrence N. Mugambi. In that earlier ruling, the court found that the Honorable Chief Justice could lawfully empanel a bench, notwithstanding her status as a petitioner in Milimani High Court Constitutional Petition number E083 of 2025. The sixth petitioner observes that the present application is not in the nature of an application to review the ruling dated and delivered on 25th April 2025 by Honorable Mr. Justice Lawrence N. Mugambi, nor can this High Court sit in an appeal of that decision of that High Court. Accordingly, the sixth petitioner argues that the first interested parties attempt to revisit the same question by way of this application offends Section 7 of the Civil Procedure Act, which codifies the principle of res judicata. The court is urged to find that the issue is already decided between the same parties, as the first interested party was and is a party to each of the consolidated petitions, and therefore this court must decline to entertain the application in limine. The parties opposed further submit that this court lacks the requisite jurisdiction to grant the order sought, directing the Honorable Chief Justice or the Honorable Deputy Chief Justice, respectively, to reconstitute benches in these matters. It is argued that the power to assign judges under Article 165, sub-Article 4 of the Constitution lies exclusively with the Chief Justice, and is a matter of judicial administration, not subject to supervision or direction by the High Court. The Honorable Attorney General further argued that there is no provision in law that enables High Court bench to return a matter to the Chief Justice for reassignment once a bench is seized of a petition, that the bench has a duty to hear it to conclusion unless lawfully disqualified. It is further contended by the second respondent that any perceived impropriety in the Honorable Chief Justice Administrative Act can only be subject to a separate judicial review or constitutional petition, but cannot be canvassed at the interlocutory stages of the same impugned proceedings. The parties opposed also submit that the applicant has failed to demonstrate any real possibility of bias or lack of impartiality on the part of the bench that would warrant recusal. They urge the court to apply the well-established objective test of whether a reasonable, fair-minded, and informed observer, looking at all the circumstances, would conclude that there is a likelihood of bias on the part of the judge or judges. They argue that such an observer would be aware of the professional oaths and obligations of judges and would not jump to conclusions of bias or on the basis of conjecture or remote associations. It is further submitted that no concrete facts have been adduced that link any of the three judges appointed to form the present three-judge bench to a disposition favoring the petitioners, predisposing them to automatically hold or determine in favor of the petitioners. Counsel noted that granting a conservatory order at an interim stage does not signify predetermination of the case, but rather it merely reflects a preliminary assessment of the case as warranting preservation of obtaining status quo or the status quo ante. As regards the appointment of two judges sitting in this bench during the tenure of the first petitioner as the Chief Justice and the chairperson of the first respondent, the parties opposing the application contend that being appointed by a particular authority is not a recognized ground for recusal. If it were, all judges would be disqualified from hearing any case involving the government or the appointing authority, which, in the Kenyan context, would be the President of the Republic of Kenya, the state officer whom, by virtue of the Constitution, appoints all judges of the Superior Court. To their minds, the law presumes that judges, once appointed, exercise independent judgment. The parties opposed, citing the Supreme Court dicta in Jasbir Singh Rai and three others versus Tarochan Singh Rai and four others, 2013 EKLR, in which the Apex Court held that while litigants have a right to a fair hearing, by an impartial judge, that right does not equate to a right to unpick a bench, and a recusal application should not be used to try to influence the composition of a bench to one's liking. The parties opposed warn that the first interested parties application veers into that territory. They further argue that public confidence in the judiciary would be undermined, not enhanced, by allowing the instant application. In their written submissions, the parties opposed contextualized the present application against a background where, in their eyes, certain litigants, upon sensing an unfavorable or unpredictable bench, attempt to file complaints or applications to force the judges out. The parties opposing the application contend that acceding to such unmerited requests would set a pernicious precedent, fostering an unending cycle of bench shopping and thereby undermining the stability, integrity, and orderly administration of judicial processes. They further argued that judges have a duty to sit and hear cases assigned to them unless there is truly compelling reason to recuse. In support of this contention, the parties opposed relied on the decision of the Supreme Court in Raila Odinga and two others versus IBC and two others, 2013 EKLR, in which the Supreme Court stressed that recusal is not a matter to be lightly undertaken and that, absent valid reasons, judges are obliged not to recuse themselves lest they abandon their responsibility to hear and determine all cases before them without fear or favor. The opposing parties emphasize that no member of the bench has, by word or conduct, exhibited any indication of bias or partiality. They assert that the three judges seized of this matter have, throughout the proceedings, conducting themselves with utmost propriety, restraint, and fairness to all the parties before the court. The Attorney General submits that a fair-minded and informed observer would appreciate that it is not uncommon for judges to grant interim reliefs to preserve the status quo, while nonetheless retaining the capacity and obligation to impartially determine the substantive issues thereafter. It is urged that such conduct accords with the judicial oath and fundamental duty of a judge. The second respondent further contends that a strong presumption of judicial impartiality attaches to every judge, a presumption which may only be displaced by cogent and credible evidence to the contrary. In the present case, it is submitted that the applicant has tendered no such evidence, relying instead on conjecture, inference, and unsubstantiated speculation. Hearing of the application. The parties in support, as well as those opposed, filed and exchanged written submissions. The application was heard by way of highlighting of written submissions on 3rd of October 2025. At that hearing, the participating parties canvassed their respective positions as set out in the preceding paragraphs. Issues for determination. It emerges from the written submissions on record with respect to the first interested party's notice of motion application dated 9th June 2025 and the highlights of that October 2025 that the issues for determination are as follows. A. Whether the consolidated issues herein should be remitted to the Honorable Chief Justice for the empanelment by her leadership, the Chief Justice, or her leadership, the Deputy Chief Justice. B. Whether the legal grounds for recusal have been established. And C. The costs of the application. The two substantive issues, while closely related and somewhat intertwined, have sufficient unique aspects for them to be formulated, analyzed, and determined distinctly. Analysis and determination. Issue number 1. Whether the consolidated issues herein should be remitted to the Honorable Chief Justice for re-impanelment by her leadership, the Chief Justice, or her leadership, the Deputy Chief Justice. Upon a careful perusal of the issues raised for determination, the submissions of counsel, and the constitutional and statutory framework governing the empanelment of benches under Article 165 of Article 4 of the Constitution, this court is satisfied that the question before it has been conclusively settled, and thus it is functus officio in respect thereof. It is not in dispute that by a ruling delivered by Honorable Justice Bahati Mwamuye on the 10th of April 2025 and Honorable Mr. Justice Lawrence Mugambi on the 25th April 2025, The respective judges, having heard the parties, certified that the petition before them raised substantial questions of law within the meaning of Article 165, Sub-Article 4 of the Constitution. Consequently, and in compliance with the dictates of that provision of our supreme law, they refer the matters to the Honorable Chief Justice for empanelment of a bench comprising of an even number of judges, being not less than 3, to hear and determine the petitions. Pursuant to the said judicial certifications, the empanelment was duly undertaken by the Honorable Chief Justice in exercise of a constitutional discretion under Article 165, Sub-Article 4. The Court of Appeal, in Rigathi Gachagua and 5 others versus Thomas Kimotho Maingi and 80 others, 2025 EKLR, lucidly articulating the prevailing legal position as follows. Open quote. The role of the Chief Justice in setting up a bench under Article 165.4 is triggered by a matter being certified by the High Court or the Court of Equal Status as raising a substantial question of law under clauses 3, B, or D of the said article. Once the court certifies that a matter qualifies to be heard by an expanded bench, the Chief Justice cannot question that decision. Anyone aggrieved by the certification has a right of appeal to the Court of Appeal. End of quote. Or closing quote. It is therefore beyond contestation that once certification was made and the Chief Justice undertook empanelment pursuant thereto, the process attained finality. The proper recourse for any aggrieved party lay in an appeal against certification decision. No such appeal to the Court of Appeal has been preferred. To now invite this bench to revisit, reopen, or remit the matter to the Chief Justice for fresh empanelment would amount to an impermissible attempt to re-exercise a jurisdiction that has already been spent. The Supreme Court, in Raila Odinga and 2 others versus Independent Electoral Boundaries Commission and 3 others, restating the doctrine of functus officio in the following paragraphs. Open quote. Daniel Malani Pretorius, in the origins of the functus officio doctrine, with specific reference to its application in administrative law, 2005, bracket 2005, 122, SALJ 832, explicates this concept thus. The functus officio doctrine is one of the mechanisms by which the law gives expression to the principle of finality. Once such a decision has been given, it is, subject to any right of appeal, final and conclusive. Such a decision cannot be revoked or varied by a decision maker. End of close quotes. Similarly, in Just Evening Post Limited versus AI Thani, 2002, JLR 542 at page 550, it was held that, open quote, a court is functus when it has performed all its duties in a particular case. The purpose of the doctrine is to provide finality. Once proceedings are finally concluded, the court cannot review or alter its decision. Any challenge to its ruling must be taken to a higher court. Close quotes. Guided by the foregoing authorities, it is manifest that the High Court, having certified the matter under Article 165, Sub-Article 4, and consequently caused the empanelment to be affected, the court has fully discharged its jurisdiction in that respect. The High Court cannot now recall, or revisit, or relimit the matter to the Honorable Chief Justice for recertification or reassignment. To do so would not only offend the doctrine of functus officio, but also undermine the principle of finality that undergirds judicial proceedings. As to the contention that the Honorable Chief Justice, being the petitioner in Milimani High Court Constitutional Petition number E083 of 2025, and a conflict of interest, and therefore ought to have delegated a constitutional mandate under Article 165 of Article 4 to the Honorable Deputy Chief Justice, this argument is equally misconceived. The Court of Appeal, in Gachagua and 5 others, at paragraph 145 to 155, examined the scope of Section 5, subsection 4 of the Judicial Service Act and held that the Deputy Chief Justice may only act as Chief Justice in 3 defined circumstances, namely removal, resignation, or death of the Chief Justice. The court emphatically stated that the Deputy Chief Justice cannot act as a general deputy, save in those exceptional and demonstrable instances. Accordingly, neither the mere fact of Honorable Chief Justice being a party to proceedings nor the perception of conflict constitutes an exception contemplated under the law. The Constitution vests the empanelment power exclusively in the Chief Justice, and that discretion cannot be usurped, directed, or fettered by any court. Indeed, as the Court of Appeal further held in Gachagua at paragraph 213, open quote, the discretion granted to the Chief Justice by Article 165, sub-Article 4, to empanel a bench is a power solely granted to the Chief Justice. It is the Chief Justice, and she alone, who can decide the number of judges to assign a matter. Similarly, it's only the Chief Justice who can decide which judge to assign to a bench, end of quote, was closing quote. In light of the foregoing constitutional, statutory, and jurisprudential framework, this court finds that it is functus officio in respect of the certification and empanelment of the present matter. The question of referring the same back to the Honorable Chief Justice for re-impanelment does not arise. Any grievances regarding the empanelment or the composition of the bench can be ventilated through the appropriate appellate process. Accordingly, the court holds that the empanelment was validly undertaken pursuant to Article 165, sub-Article 4 of the Constitution, that the court's jurisdiction on the issue has been fully and finally exercised, and that no order may now validly issue from the High Court purporting to direct or compel the Honorable Chief Justice in the discharge of her constitutional functions under Article 165, sub-Article 4 of the Constitution. I now...
Yes, issue whether the legal grounds for the recusal have been established. The instant matter, the first interested party invited this bench either to recuse itself or to remit the consolidated petition to the Chief Justice for the reassignment. The fundamental question that arises is, has the threshold for the recusal of the bench been met by the first respondent party? The right to fair hearing under Article 50, sub-Article 1 of the Constitution, and its course independence and impartiality is a critical principles that must be insulated to protect the judicial decision-making process from bias, external influence, or the prejudices. Article 50, sub-Article 1 state quote, every person has the right to have any dispute that can be resolved by the application of the law, decided in a fair and public hearing before a court, or, if appropriate, another independent and impartial tribunal or body, close the quote. Pursuant to Section 47 of the Judicial Service Act, Regulation 21, 1 of the Judicial Service Code of Conduct and Ethics, regulations was formulated. This regulation provides for the various instances when a judge may be required to recuse himself or herself from a judicial proceeding. It states, quote, a judge may recuse himself or herself in any proceedings where their impartiality might reasonably be questioned, including where the judge A, in a party to the proceeding, B, was or is material witness in the matter in controversy, C, has a personal knowledge of the disputed evidentiary fact concerning the proceedings, D, has actual bias or prejudice concerning a party, E, has a personal interest or is in a relationship with a person who has personal interest in the outcome of the matter, F, previously acted as a counsel for a party in the matter, G, is precluded from hearing the matter on account of any other sufficient reason, and H, has family member with an economic or other interest in the outcome of the case. Close the quote. Nevertheless, it must be appreciated that this does not mean that these are the only circumstances a judge should recuse himself or herself in a matter. As stated by the Supreme Court in Rai and three others cases, 2013 KESC 2020 Kenya Law Report, quote, the circumstances calling for a recusal for a judge are by no means cast in stone. Perception of fairness, of conviction, of moral authority to hear the matter is a proper test of whether or not the non-participation of the judicial officer is called for. The object in view in the recusal of a judicial officer is that justice as between the parties be uncompromised, that due process of the law be realized and be seen to have and had its role, that a profile of the rule of law in the matter in question be seen to have remained uncompromised. Close the quote. In our view, the threshold of the recusal was aptly laid down by the Court of Appeal in the case of Rawal for the Judicial Service Commission and another, Koiti, Interest and Party, International Commission of Jurists and another, Amicus Curie, 2016 KECA 534 Kenya Law Report, which citing the decision of the Supreme Court of Canada held that the Supreme Court of Canada expounded the test of the following terms in R versus S in brackets RD 1977 3 SCR the 484. Quote, the apprehension of bias must be reasonable, one held by reasonable and right-minded persons, applying themselves to the question of obtaining thereon the required information. The test is what would an informed person, viewing the matter realistically and practically, and having thought the matter through, conclude. This test contains a twofold objective element. The person considering the alleged bias must be reasonable, and the apprehension of bias itself must also be reasonable in the circumstances of the case. Further, the reasonable person must be an informed person with the knowledge of all the relevant circumstances, including the traditions of the integrity and impartiality that form part of the background, and apprised also of the fact that impartiality is one of the duties the judges swear to uphold. The reasonable person should also be taken to be aware of the social reality that forms the background to a particular case, such as societal awareness and acknowledgement of the prevalence of the racism or gender bias in a particular community. The jurisprudence indicates that a real likelihood and probability of the bias must be demonstrated, and that a mere suspicion is not enough. The existence of a reasonable apprehension of the bias depends entirely on the fact. The threshold for such a finding is high, and the onus of demonstrating bias lies with the person who is alleging its existence. Close the quote. That is the tests we propose to adopt in this application, as it is accepted test. Do the grounds relied upon by the first interested party meet the above test? Firstly, none of the said ground relied upon by the first interested party in his application for this recusal that specifically falls within the range of the circumstances specified upon under the Regulation 21(1) of the Judicial Service Code of Conduct and Ethics Regulations, meaning the statutory test was not established. Having failed the obvious and the more direct test, the next limp is to consider whether alleged apprehension or bias by the first interested party is reasonable in the circumstances of this case. The Constitution of South Africa, in the President of the Republic of South Africa and others for the South African Rugby Football Union and others, 1999, articulated the test for the apprehension of bias thus, quote, the question is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the adjudication of the case. It must be assumed that the judges can disabuse their might of any irrelevant personal beliefs or predisposition, They have a duty to sit in a case in which they are not obliged to recuse themselves from the court. Similarly, the Supreme Court, in the case of Gladys Bush Soleil, as the Judicial Service Commission and another, 2018 Kenya Law Report, citing the case of Simpson General Motors Corporation, USDC 425 R sub 574 578 1978, emphasized the duty to sit, stating that, quote, recusal, reassignment is not a matter to be lightly undertaken. While in proper cases, we have a duty to recuse ourselves, we have a concomitant obligation not to recuse ourselves. Absent valid reasons for recusal, there remains what has been termed as a duty to sit, close the quote. The obligation to demonstrate there exists reasonable apprehension of bias is essential so as to safeguard judicial independence by ensuring that judges do not recuse themselves on flimsy grounds, and that litigants cannot, through speculation and pressure, manipulate the composition of the court. We have carefully assessed each and every allegation made against this bench and defied nothing but unsubstantiated allegations that are devoid of any evidentiary or legal basis. The allegations range from regional and gender composition of the bench, perceived and inexperience by members of the bench to handle complex constitutional questions, that two of the judges had and granted conservatory orders in favor of the petitioners here, hence have formed their mind, that two of the members of the bench were appointed during the tenure of the Chief Justice, who is the petitioner, hence beholden to her, and so on. In our humble view, these are mere sensational allegations that have no bearing on the impartiality of the bench. To act on such allegations will subvert the integrity of the institution and the constitutional obligation imposed upon judges to discharge their duties without fear or favor. The argument advanced by the first interested party with regard to his perception that the judges of this bench are relatively junior can be easily settled by reference to the seminal decision of the Court of Appeal in the case of Bat versus Rent Restriction Tribunal, 1979 Kenya Law Report, in which the court famously held that, quote, a judge of the High Court has the same jurisdiction and power as any other judge of the High Court. There are no senior or junior judges in the High Court. All are equal in jurisdiction and authority, close the quote. Accordingly, any suggestion that the judges constituting this bench lack the requisite seniority or expertise or experience to sit together is totally misconceived and without merit. All judges of the High Court derive their authority from the same constitutional source, Article 165, and exercise coordinate jurisdiction. The grounds advanced do not satisfy the statutory or jurisprudential standards for recusal. All judges of the High Court enjoy equal constitutional standing, and this court finds no reason to send the consolidated petition to the Honorable Chief Justice for a certification or empanelment. Issue number 3 is the cost. This court has no reason to find that the application, where unsuccessful means meets any of the criteria that would require the unsuccessful applicant to bear the costs of the application. Noting that the consolidated petitions here touch on matters of public interest, we find that it is fit, right, and proper that each party bear its own costs in the application. So the final orders, for the foregoing reasons, the first interested party's notice of motion application dated 9th June 2025 is found to be without merit and is dismissed accordingly, with each party to bear its own costs in the application. The court will also, after delivery of this ruling, proceed to issue comprehensive direction towards expedited hearing and determination of the consolidated petitions herein. Those are our orders at long and short of this ruling.
There are not of that in the order, so